Did you know that North Carolina has one of the highest divorce rates in the United States, with approximately 3.1 divorces per 1,000 inhabitants? This startling statistic underlines the importance of understanding the divorce process in this state. With such high rates, it's not a stretch to say that some of us, or someone we know, might need to navigate this legal terrain. So, what does it take to get a divorce in North Carolina? Let's dive in. The first requirement for divorce in this state is living separate and apart for 1 year and a day. Now you might wonder, what does living separate and apart actually mean? Well, let's dive into this a little deeper. Imagine you and your spouse decide to split. You move into the basement while your spouse takes the master bedroom. Does this count as living separate and apart? Nope. Living separate and apart means maintaining two completely distinct residences. The basement, the garage, or even the baby's room in the same house doesn't cut it. Now, what about on and off relationships? Let's say you and your spouse have a pattern of breaking up, moving out, reconciling, and moving back in. If this cycle happens within a year and a day, it doesn't qualify as living separate and apart. You see, the rule here is consistency. You need to maintain separate residences for a full year and a day, without any breaks in between. And remember, this is not just about physical separation. It's also about intent. You and your spouse must intend to live separate and apart permanently. If you're just taking a break or testing the waters, it doesn't count. Now let's talk about the importance of the 1-year rule. You might think it's a long time, but this period is designed to give couples time to reflect, reconcile, or prepare for the legal, financial, and emotional implications of divorce. It's not a decision to be taken lightly, and North Carolina law respects that. So, to sum up, living separate and apart means maintaining two completely separate residences, with the intention to remain separate for over a year and a day. It's a clear-cut, no gray area kind of rule. Any deviations, be it living in the same house or having an on and off relationship, simply don't meet this requirement. Living separate and apart means having two completely separate residences for over a year. Along with physical separation, there needs to be an intention to remain separate and apart permanently. This is a crucial component of the divorce process in North Carolina. Let's say, for instance, that John and Jane decide to live separately. They have their own residences, but they frequently spend weekends together, with the hope of rekindling their relationship. In this case, despite their separate residences, the intention to remain separate permanently is lacking. This could potentially invalidate their separation period in the eyes of the law. Similarly, if Sarah and Sam, another hypothetical couple, live separately but maintain a pattern of breaking up and moving back together every few months, this on and off relationship indicates a lack of permanent intention to separate. They cannot count this time towards their 1-year separation period. The intention to remain separate is a commitment. It's not just about physically living apart, but also about emotionally and mentally preparing for a life apart. Without the intention to remain apart, the physical separation becomes meaningless in the eyes of the law. Another critical requirement is that at least one spouse must have resided in North Carolina for 6 months immediately before filing. Let's put this into context. Imagine a couple where one partner has moved to another state for a job, while the other stayed in North Carolina. Even if the spouse who moved away initiates the divorce, the fact that the other spouse has remained in North Carolina for the required period means they meet this residency requirement. Or consider a scenario where both spouses have moved out of the state. If neither spouse has resided in North Carolina for at least 6 months before filing, they wouldn't be able to proceed with the divorce here. They'd have to file in their new state of residence. This requirement isn't about keeping tabs on where you live. It's about jurisdiction, ensuring that North Carolina has the legal authority to grant the divorce. This requirement ensures that North Carolina has jurisdiction over the divorce. Once all these requirements are met, spouses can file for divorce. So, let's delve into the filing process. It's important to note that you do not need a separation agreement before filing. However, having one could be beneficial in streamlining the process, as it helps outline the terms of the separation. Now, you might think that you need a specific legal reason to file for divorce, such as infidelity. That's not the case in North Carolina. You don't have to prove that your spouse was unfaithful or that there were other marital issues. The state allows for no-fault divorces, which means you can file for divorce without having to prove any wrongdoing. While this might seem straightforward, there are a few more factors to consider before you head to the courthouse. It's crucial to resolve certain issues before filing. These include equitable distribution, custody, child support, and spousal support. Let's start with equitable distribution. This refers to the division of the couple's property. It's essential to come to a fair agreement on who gets what, from the family home to the smallest piece of jewelry. If this isn't settled before filing, it could lead to drawn-out legal battles later on. Next, we have custody and child support. If you have children, deciding who gets custody and establishing a child support plan is paramount. It's always best for the parents to come to an agreement on this, but if that's not possible, the court will have to decide. Lastly, there's spousal support, often referred to as alimony. This is financial support provided by one spouse to the other after divorce. It's designed to limit any unfair economic effects of a divorce by providing a continuing income to the lower wage earning or non-wage earning spouse. Remember, it's always best to resolve as many issues as possible before filing for divorce. This way, you can avoid unnecessary legal battles and ensure a smoother, quicker divorce process. Navigating the complexities of divorce laws can be challenging. Indeed, the path to divorce, riddled with legal intricacies, can be a daunting journey for anyone to undertake alone. This is why seeking professional legal advice is highly recommended when considering a divorce. Picture this. You're lost in a foreign city with a map written in a language you barely understand. Now, wouldn't you rather have a seasoned local guide to help you navigate? Similarly, an experienced attorney can guide you through this maze of divorce laws, ensuring you don't miss any critical steps or overlook any crucial aspects. An attorney doesn't just provide legal advice, they can also offer strategic guidance tailored to your specific situation. They can help you understand and weigh your options, foresee potential challenges, and prepare for them in advance. Moreover, an attorney can also serve as an objective third party during this emotionally charged time. They can help you make decisions that are in your best interest, rather than letting emotions cloud your judgment. Let's not forget the legal paperwork. Attorneys are well versed in the language of law and can help ensure all your documents are in order, further simplifying the process for you. And finally, an attorney can represent you in court if necessary, arguing your case and protecting your rights. Remember, every situation is unique, and professional legal advice can be invaluable in navigating the divorce process. So don't hesitate to seek out the guidance and support you need. Divorce can be a challenging process, but understanding the requirements can make it a little easier. Let's take a moment to recap what we've learned. Getting a divorce in North Carolina is not as simple as signing a piece of paper and calling it quits. There are specific requirements that must be met before a divorce can be granted. Firstly, living separate and apart for 1 year and a day is paramount. It's not enough to just live in different rooms or even different parts of the same house. Separate residences are a must. This means that sleeping in the baby's room, living over the garage, or residing in the basement does not qualify as living separately. Moreover, the separation must be continuous. On-again, off-again relationships where spouses move out and then move back in for less than a year and a day do not meet the criteria. The intention to remain separate and apart permanently is crucial in this process. Then, there's the residency requirement. At least one spouse must have resided in North Carolina for 6 months immediately preceding the filing of the divorce. If these conditions are met, only then can the parties file for divorce. It's also important to note that you don't need a separation agreement before filing, nor do you need to prove infidelity or any other legal reason for the divorce. However, it's often beneficial to settle matters such as equitable distribution, child custody, child support, and spousal support before filing. Navigating the intricacies of these requirements can be overwhelming, hence the importance of seeking legal advice cannot be overstated. It's always wise to have a professional guiding you through this complex process. Remember, despite the high divorce rates in North Carolina, understanding these divorce requirements can make the process a little easier. It's all about empowering yourself with knowledge. Remember, knowledge is power, especially when it comes to the complexities of divorce.